will now proceed to the second plenary on cybersecurity. In this session, we're going to focus on domain name abuse. In particular, we're going to explore the legal interoperability in terms of mechanisms, frameworks, norms, and criteria. The moderator for this session is Mr. Edmund Zhong, the CEO of .Asia. He is joining us online. Please welcome the moderator for the session, Mr. Zhong. Mr. Zhong, the floor is yours.
Hi, everyone. This is Edmund. Thank you for having me. Very excited to join this event. And thank you, TWNIC and Icann APAC Hub for hosting this event. Unfortunately, I couldn't come to Taipei. I would have loved to come and join you in person, but still excited to get this underway. So this is the second plenary for the event, and as mentioned as the agenda, we're going to look at a little bit of a different dimension on cybersecurity relevant to the DNS and the Icann community, and there are different really ways to address different forms of domain name abuse or abuse that related to the DNS and Icann. So we're very glad to have assembled a distinguished panel here with us for the session. Thomas Cooper, General Manager of Gandhi and Icann Accredited Registrar. Crystal Peterson, Director of Registry and Franchise TLD Business Affairs at GoDaddy Registry. Kiran Sangera, Special Counsel at the Hong Kong International Arbitration Center, HKIAC. Henry Tsai, Division Chief Judge here actually in the Taiwan Shilin District Court. He's probably the only one there with you from the panel and at the venue. And also Jamie Hedlund, Senior VP of Contractual Compliance and Consumer Safeguards at Icann. So before I turn over to the panel on this particular topic, I wanted to open with a little bit of a clarification from my presentation yesterday, which also hopefully sets the stage for the discussion today. So if you can help share my slide, I don't know whether the slide is coming up at the forum. 不知道工作人员可不可以收我的 PPT? Oh, thank you. So yesterday I gave this presentation, and the fact that it stirred up quite a reaction is perhaps a testimony to how hot and sensitive this particular topic is. I tried to say I just want to clarify that I tried to say this DNS abuse ecosystem, quote unquote, has a lot of aspects within, there are some aspects within the Icann purview, but a lot more beyond Icann. And there are DNS related stuff. There are also other infrastructure and other content. And I made the mistake by just stopping here with the abuse, identifying a number of different areas. What I really wanted to say, and I want to make sure that this particular point is not missed, is that the very narrow slice of scope for Icann is definitely part of it, but DNS abuse is one thing. There's also other types of content abuse and infrastructure abuse. But yes, and so I actually agree very much with my colleagues in that, especially from the registry and registrar, that there is a lot of abuse that we need to deal with. DNS abuse is one of them, but within Icann's purview for policy, it's actually a very narrow scope. I do just stand a little bit apart from my colleagues in thinking that even though it's a very small slice, maybe Icann can do something. And it is within that small slice that Icann can exemplify its work, just as like the very successful UDRP has really made a big impact on the internet as a whole as well. So with that clarification, I will go to our first speaker. And I think our first speaker is also there with you in Taiwan, Thomas Cooper from Gandhi, who will share with us I think the Icann accredited registrar perspective on some of these things.
Correct, yeah. Can you hear me well, or can you hear me at all? You can hear me, right? Okay, yeah. That's
Yes,
the first
I can
thing,
hear
right?
you.
I'm not on mute or something. Okay, yeah. So, yeah, first of all, I'm very happy to be here. We are also a sponsor of this conference, and it's the second time we do this conference with TWNIC. And I'm very happy that TWNIC is doing so much actually to reach out to the community and organizing this kind of things. Unfortunately, in Asia, it should be much more, and we should push much more that Asia, the region, gets much more involved in Icann processes as well. It's very much, I'm from Europe, okay, so I know this very well. There's a big US dominance in the internet industry, and I think we have to think more about the European customers, their language, and so on, to have better support for those kind of people and those kind of stakeholders. So could we put up my presentation? I don't know if you can see it. Yeah, all right. So I'm going to talk a little bit about avoiding malicious registrations. So we are based in Taiwan as Gandhi since 7 years. Is where I live as well, and I have been stuck since 2 years almost now because of COVID. But we have this office here since 7 years. Gandhi itself is over 20 years old. We also have brand protection services, and so we know very well what is going on in the world with trademarks being abused online and providing good service for our customers for brand protection. Next slide, please. Or should I go? Okay, yeah, good. Yeah. So we have a definition of what is DNS abuse. So DNS abuse is malware, botnets, phishing, farming, spam. And the slide you see here, this is a definition. Sorry if it's a bit too much text. It's a definition by which the registries and registrars of Icann agreed what is actually a definition of DNS abuse. And most of these things, they are sent by email. So spam is one of these things as well, but it's not directly related to DNS. But as you probably know, everybody's affected by this. I hit my delete button at least 100 times every day, okay, because I'm working so much with email. And everybody gets this email. I'm not doing any effort actually to report these scams. I'm not doing any effort to actually say to the registrar, whoever was responsible of the domain name or the mail provider, to report this. So there's some improvement that has to be done there. Actually, that people can do better reporting of scams and provide a better method also to make the user actually aware that these things can be reported and there must be something done about it. But in reality, the problem is we don't have enough data ourselves as registrar or even the other registrar. Nobody's publishing any information how much phishing attempts they have been the target of, and even ourselves, we get phishing attacks. We get people who abuse our own name as a registrar to tell them, okay, hey, your domain name has to be renewed, you need to pay some money, but that email is not from us. So everybody is affected by this. Everybody is in some way involved, but there's very little standardization, very few statistics actually how to report these things, how much actually is there, but we all know it exists and we all know it's increasing. So I was looking a little bit into Spamhaus, which is one of the few things where you can find the statistics. And I found out actually that it seems like every time there's a cheap domain name, what they observe at Spamhaus is that the amount of abuse is going up. So in this case, no offense, Edmund, okay, it's not your fault. .asia this week is in the top 10 of the most abused domain names, but this is only what Spamhaus is seeing. This is only the DNS traffic that they can observe where we have been abusive registrations. And when you check then, this domain name, is it cheap? Mostly it's yes. So one of the reasons that domain names get abused for DNS abuse is because they are cheap. I observed this myself, okay, because we do business in Asia since 7 years. Once we sell something cheap in China, for sure we're going to have abusive registrations. The main reason is that these people who do these abusive registrations for phishing and other scams, for them it has no value. They're not going to renew those domain names, right? They already know there's going to be a UDIP at some point or just deletion. So they just look for the cheapest domain name to run their scam. And a lot of times as well, it's not just one actor, but maybe it's just a handful of actors who buys a lot of domain names. Some registries then had the idea, okay, hey, we can do some ID verification. Maybe we're going to have less scammers. But if you look at the statistics of Spamhaus, then you see, okay, actually .cn in China, which has a lot of domain names, the traffic they see of them is more than 7.6% bad of the observed domain names. So this is not all the .cn domain names, but the one they observed has 7.6% bad or some kind of spam-related activity, even if .cn requires a passport. .tw in these times, okay, probably also there's a promotion somewhere, is having some impact as well. .com only 3.1%, no ID verification. XYZ, even if it's most of the time is very cheap, is not that bad. And .de, which has 16 million domain names, no verification, is actually very low. So it really shows you there's a probably more price related, probably more geographical related to have a verification, to have spams, but ID verification doesn't actually solve the problem. Then, unfortunately, it seems to be a trend still, because people say like, okay, if we have someone's ID, we're going to have more security, right? So if we give someone's ID, it means they're safe, they're secure. And I was a bit surprised about the initiative which is run by .cz.dkee, which is Estonia, and NL, which is the Netherlands. They say, okay, they're going to do an ID check in the future. They are going to allow other EU registrants also to register their domain names. For sure, having a geographical limitation on registering a domain name helps against spam and against scams or DNS abuse, but the problem is actually that the ID check doesn't help because their score is already very low. I don't think they actually need this. So there's another thing, which is the reputation of registrars, and as Edmund said, this is also the purview of Icann. There's actually registrars which are based in legislations which don't have any kind of anti-spam legislation or any kind of computer security or computer crime laws. And those registrars, they also don't act, again, because there's no standardization about reporting those issues. So those registrars, they can have a very bad index on Spamhaus, which is also actually making statistics on registrars, not acting or not acting fast enough when there's a scam. Some of these are very big, so it's also size of the registrars and also related to the TLD which was registered. And so you can see that, okay, there has to be something also to increase the thing from registrars about connecting statistics themselves, or having Icann do more about reaching standard procedures with registrars, or actually penalize the registrars themselves who are having a high amount of abuse. And so for me, the way forward, and that's my final slide, there has to be better monitoring and punishment of bad registrars, so more collection of statistics from everybody. There has to be more anti-spam legislations by some countries in the world. Price dumping has to stop. It's better you sell a domain name as a bundle with another product, and instead of just selling the domain name at under $1. Brand owners, they have to make more use of monitoring so they can actually avoid those scams in the first place. We provide a very comprehensive monitoring solution actually at Gandhi. And also collaborate with the Dns Abuse work group. TWNIC, I heard, is also a signer of the DNS, the initiative against DNS abuse. And there's other initiatives by Public Internet Registry, Domain Name Institute, which is focusing also on working these kind of things to reduce those things in the future. But they're all very Anglophone, they're all very English-centered, they're not very user-centric as well. So there must be more standards for providing not just education about phishing and malware, but also how to better report it internationally in any language. And because if I complain to Icann, I personally had some complaint to Icann myself about a phishing I received, but because the registrar didn't reply, but actually there was no, in the end my case was just closed because they didn't have enough time, or I don't know. So for me it's not a fault of Icann, but I think we have to do much more as stakeholders actually to be more user-centric about fighting spam and phishing. Yeah, and that's also my last point about educating people about those complaints. Okay, thank you.
Thank you, Thomas. I think that's a very important point, to be more user-centric and probably to work with different stakeholders in the community as well. And thank you for highlighting .Asia. We are working on it. We do see it, and we are working on to mitigate it against, especially when we have price promotion. Actually, our team also looks at the domain abuse situation during the promotion. So with that, moving on to our next speaker, Crystal Peterson, to give us a perspective from the registry side.
again, thank you, everyone. It is a pleasure to be back. I was at the first forum, and it is a pleasure to be back to be able to share with the esteemed community, both online and there in the room. So GoDaddy Registry, we have the unique position of being both a CCTLD administrator, such as with the .us and .co CCTLDs, as well as a registry operator for several GTLDs, including .biz, .compare, .select, among many others. In addition, we also provide registry backend services for over 200 other TLDs, many of whom have additional policies and support requests in the area of abuse and acceptable use. We look to leverage best in breed and enterprise grade technology to enable the millions of people who do count on us, for internet commerce and communications to seamlessly interact. And we know that, failing to prevent malicious actors from using domain names for abusive purposes can weaken reputation and trust in the entire domain name space. So we take, very seriously our role. And as part of our registry agreement with Icann, we conduct malicious monitoring and security reviews for technical forms of abuse. Along with that, we conduct abusive reviews for all of our CCTLDs who also maintain acceptable use policies and abuse policies in addition to their registration policies. As a registry operator or administrator, our policies seek to adhere to the customer relationship between the registry, the registrar, and the end user. So in the vast majority of cases, any report of abuse is referred directly to the sponsoring registrar in the first instance before we as a registry operator will take any action overriding the registrar relationship. Not to mean that we won't, but we do seek to look at that funnel first. As a requirement for our registry agreement and MIT for those TLDs where we do have a China registry license, an abuse contact is also required to be posted on our websites. However, very little contact is received via this method, generally less than once a month, and is typically not an abuse-related inquiry. So this is not necessarily our main funnel for receiving abuse complaints or being able to mitigate abuse. Wanted to describe a little bit, the Registry Threat Mitigation Service, or RTMS for short, is a proprietary system that we have developed, which includes a highly advanced mitigation process and leverages notifications to registrars, has time limits for actions where appropriate, and domain name takedowns using a registry level hold, or what we call server hold. This process allows the suspension of domain names involved in many information security threats, such as phishing, malware distribution, botnet command, and control activity. Certain TLDs may have also custom processes, which we have integrated into this platform as well. Our registry investigation team manages hundreds of alerts per month through certain data feeds and notification networks that we subscribe to. For example, a selection of 3 TLDs for which we are the registry operator. We receive around 700 alerts per month. About 10% are actioned by the registrar from communications with them where they utilize a client hold. And then about 5% are actioned by the registry where we put the setting of server hold. And then the remainder tend to be cleared alerts, but all are investigated to look to see if action needs to be taken. So now I'd like to get into several of the partnerships that that we have set up as Edmund was just mentioning previously. So in addition to some of the requirements that we have with abuse monitoring, we join forces with many companies and partnerships throughout the industry. One of those is the framework to address DNS abuse, which addresses content such as CSAM, child sexual abuse materials, illegal distribution of opioids, human trafficking, and specific and credible incitements to violence. Underlying these content abuses is the physical and often irreversible threat to life. And so we have joined forces and have signed on to that framework. Next, we also have entered into what we call a trusted notifier arrangement with the Internet Watch Foundation, or IWF for short, for the .us, .co, and .biz TLDs. And this is for the mitigation and review of sites and or domain names containing child sexual abuse materials, or that CSAM. GoDaddy Registry determined that this arrangement would be beneficial, and we have had excellent results to date. For an example of what we do and what we look through here, when an alert is received to the designated email address from the IWF, the IWF then, that alert is sent to the National Center for Missing and Exploited Children, or NCMEC, for reference. To limit exposure, only one team member is able to review that alert and sends an email to the relevant registrar, giving a 72-hour period in which to take action. As mentioned previously, our goal is to include registrars in the notification and mitigation process. And the case is first served to the registrar before we would take any action overriding those relationships. The domain name is then placed on server hold if the registry takes action, client hold if the registrar takes action. But we have less than 10% of registrars who do not respond. In most months, within the 3 TLDs that we do have the relationship with, we have very few alerts. There are between 1 to 3 alerts that we receive. And lastly, I'd like to talk about our public-private partnership with the U.S. Food and Drug Administration, the FDA. Along with PIR, the registry operator for .org, and VeriSign, GoDaddy Registry has partnered with the NTIA and FDA to determine notification procedures and timelines for domain names that are being illegally used to sell opioids and other pharmaceuticals. This program is called the Trusted Notifier Pilot Process. The pilot was 3 months in duration, from June to early September 2020. And it allowed the FDA to be a trusted notifier and identify relevant domain names and submit them to the participating registry operators for assessment and then potential action if warranted. And all of the actions that we took were based on our policies and procedures. And some of these actions could include putting the domain name on server hold, deleting the domain name, or redirecting the name servers to a landing page that was identified by the FDA. GoDaddy Registry also looked to create a watch list of key terms, and these domain names containing the terms were reviewed, and then any concern was then relayed back to the FDA for review and input into that trusted notifier process. This pilot, we believe, enhanced the effectiveness of the FDA's existing program by engaging the registries to be able to take action. And with this voluntary collaboration with the NTIA and FDA and registries, it has helped to curb access to opioids illegally being sold online, while still having the technical safeguards for the DNS. And so currently we are continuing the collaboration with the FDA as a trusted notifier. And that, Edmund, takes care of my presentation. Thank you very much for allowing me to present.
Thank you, Crystal, giving us a very comprehensive view from the registry side of things, and especially the work, I think the volunteer commitments is a very important aspect of a lot of the GTLD registries that are in the community. So with that, we kind of switch gears a little bit and turn to another dimension of type of abuse in terms of the what the UDRP takes care of. So I'll turn to Kiran.
Great, thank you. Thank you very much, Edmund. I've also shared my slides, so hopefully those can be seen by those online and both those in person in Taiwan. I'm not seeing any reactions to the otherwise, so I'll crack on. Just also firstly to say a huge thank you to Icann and also to TWNIC for the invitation to HKIC to speak today on what is a very important topic. It's also a pleasure to share the panel and actually learn so much already from the other panelists. So in the context of today's session, what I will be focusing on is what we do here at HKIC, domain name dispute resolution, as one of the measures that can be taken to counter domain name abuse. I'll focus essentially on the key policies that we see in our work here in Hong Kong, looking a bit at the procedure and also demonstrating how these policies are implemented in practice by sharing some of our experiences here at HKIAC. So just very briefly, a bit of a snapshot really as to what we're talking about when we're talking about domain name dispute resolution in the context of what we do here at HKIAC. Probably not much need for point number one, but in essence, why should you be disputing a domain name, the ownership of a domain name? Well, it is essentially to tackle misuse, to prevent fraudulent use, to prevent competitors and others from deriving benefits from your brand and your business goodwill. But who can dispute the ownership of a domain name? Essentially what that means for us is who can file a complaint. Anyone who wants to protect their rights in relation to the domain name, essentially and most frequently, that's the owner or licensee of a registered trademark, and the complaint will be brought against the domain name registrant. In terms of the procedures that are available, this is point 3, there are several different procedures. They're quite similar, but as to which procedure will apply depends on the domain name category. So whether they're traditional GTLDs, CCTLDs, new GTLDs can have an impact on the type of policy and the rules that will apply to resolve the domain name dispute. A few of the policies, and we've talked about UDRP already, are listed there. Again, the procedures are fairly similar, but complainants must file under the relevant procedure in order for us to take the case. Who decides the outcome? It's a domain name panelist. The panelist is appointed by a domain name dispute resolution service provider, such as HKIAC. And what are the outcomes? The domain name can be transferred back to the complainant or to the complainant. It can be cancelled. Also, if the complainant is unsuccessful, then the complaint will be rejected. And it's to the registrar to implement the decision of the panelist. It's a pretty popular method to counter domain name abuse for 2 essential reasons that are listed here. It's a pretty simple and effective procedure, and it's time and cost efficient. So just on the first point, paper-based, so there aren't usually any hearings, although there can be, but it's extremely rare. So it's handled on the documents that are submitted. Please, possibly for many, but lawyer involvement is optional. A lot of the cases that we see, the complainant nor the respondent, if they participate, are legally represented, although they can be. And probably most importantly, it's highly successful for complainants. In our cases last year, over 96% of the cases that were filed with us resulted in a transfer. On top of that, it's transparent because all decisions are published by the domain name dispute resolution service providers on their websites. So there's a wealth of information about how this really works in practice. It's cost effective. There's one fee which covers the service provider's fees as well as the domain name panelist fees. And the fee structure is pretty simple. It depends on the number of panelists, 1 or 3, and the number of domain names. I've listed a figure there. Usual time frame, I've listed here 60 days, but that's really the maximum. Cases can be resolved within as little as 6 weeks, and commonly that's the case. All very important factors to maintain the integrity of the brand and to eliminate as soon as possible any domain name dispute. The structure here, I think, is probably helpful for people to understand certainly many of the acronyms that are used. So Icann sits at the top of this tree and effectively has approved a certain number of UDPR, domain name dispute resolution service providers, to administer domain name disputes under that particular policy. They're listed there in the second row, and ADNDRC is the Asian Domain Name Dispute Resolution Center with the Secretariat here in Hong Kong. And so its focus is very much on the Asian users, albeit sometimes and frequently European and US counterparts. So within that structure, ADNDRC has 4 offices, one in Seoul, one in Beijing, one in Malaysia, and the orange box is us here, HKIAC, and we were one of the founding members. So ADNDRC has been in existence for 20 years, handling essentially UDRP matters. What do we see? Which policies are coming up frequently, and what can we do? So those highlighted in orange are the ones that we see most frequently. We can handle, as the previous slide suggested, UDRP matters, so GTLDs, new GTLDs, and certain CCTLDs in our role as the Hong Kong office of the ADNDRC. There are other policies listed there, including the Uniform Rapid Suspension System, which we can also administer, but by far most frequently our matters involve UDRP, the UDRP. As HKIAC, we've also been appointed in our own right as a body to handle .hk and .cn and .ph disputes. Again, most frequently we see .hk and .cn at HKIAC. So what, I suppose, what's the role of a domain name dispute resolution service provider? It's effectively to monitor the procedure, to make sure, importantly, that timelines are met. And our role, it really gets kicked off when we receive a complaint. The first thing we need to do is request the registrar, whoever that registrar may be, to lock the domain name, to effectively maintain the status of that domain name throughout the procedure until the final decision is made and the registrar is informed. We also importantly need to obtain the respondent's contact information. It's incumbent on the dispute resolution service provider to notify the respondent of the complaint. So we need to ensure that we're notifying them appropriately and accurately. We also review the complaint for compliance, and if there are any deficiencies, the complainant has 5 days to correct those. And then really we work as a conduit for communications. As mentioned, we communicate with the registrar, we communicate with the parties, as well as the panelists, and we make sure that the various timelines are met. This has to be an efficient and effective process, otherwise the attraction of it certainly does fall away. So in light of that, the respondent then has 20 days to file its response. Whether it does or does not, and often respondents don't participate, upon the time frame elapsing, the 20-day time frame elapsing, we will appoint a panelist within 5 days. This is probably the most important thing that a DNDR provider will do. We must do that within 5 days of the response being submitted or that date being triggered. And we take into account language, very crucial, especially in this part of the world, ensuring that the panelist is impartial and independent, making sure they have the requisite experience and expertise in a particular industry, if that's relevant. The panelists will then have 14 days to make a decision. Again, that's a short time frame, and it's important that that's adhered to. Once the decision is sent back to us, we will notify that decision to the parties, as well as to the registrar, in the case of UDRP, also to Icann. The registrar will then implement the decision, if that's a transfer or cancellation, after 10 business days of being notified. That's to ensure that if there are any other actions in the courts or elsewhere, that they're aware of those, as that may impact the implementation of the decision. We'll then pay the panelists fees, and also we are required to publicize the decisions on our website, and all DNDR service providers are required to do the same. So that's effectively the role that that we play in this process.
Just a quick note on time, Kieran.
Okay, sure. 3 elements are listed here that complainants must prove to be successful. It's the same for each case. I won't go through these in detail. Many of you will probably be pleased to know. But essentially, the domain name, if it's identical or confusingly similar, that the respondent has no rights or legitimate interests in the domain name, and that the domain name has been registered and is being used in bad faith. I'll whiz through here to put a bit of colour on this, what we're actually seeing and how effective this process is in practice. So we had 149 cases. The majority were UDRP, then CNDRP and HKDRP. The parties in our cases reflect the work that we do and where we sit in the world. The majority of our cases come in from mainland Hong Kong, but also involve European and US parties. As you can see there, the complainant top party is mainland, but also by quite a margin, the top respondent are also from mainland China. Case split, again, because of where we sit, English and Chinese language, 50-50 in the cases that we handle. In terms of the appointments, most of those were made in the UDRP cases, unsurprisingly, and the majority of them last year were sole panelists. You can appoint 3 panelists, but it's quite rare. It goes to the efficiency to just appoint 1 person to resolve the dispute. Again, you can see there the nationalities or the origins of the panelists. Because of the bilingual nature, most frequently Hong Kong panelists are appointed. Just to finish on this, I think really going back to how effective the process can be, there isn't much difference across the 3 policies, UDRP, CNDRP, and HKDRP, in terms of how successful they can be for a complainant. In the majority of the 139 decisions, 134 of those resulted in a transfer of the domain name. On some occasions, in fact, the domain name was cancelled by the panelist upon the request of the complainant, and in 2 instances, the complaint was denied. So by a long way, the most common outcome for a complainant is that the domain name is effectively transferred. I appreciate I may have run over somewhat there, but that's kind of the outline that I wanted to provide for all of you today. So I will pause there. Thank you very much.
Thank you, Kieran. Not a problem at all. It's good to see that this really long-standing Icann policy, the UDRP, I think it is the first consensus policy that came out of Icann that is still useful and still making an impact. So with that, I will go on to Henry Tsai, who's there with you at the venue, I believe, and maybe take a look at it from another angle on the UDRP as well. Henry?
Hi everyone. I'm so honored to be here, to be with you to talk about domain name abuse. And as you can see, my title, the stakeholder I represent would be the public authority or from the court. So I put a subtitle, focus on the court's hopes. Okay, let's start. Okay. Yeah, I think that the domain name abuse is a very important issue in the internet community. As you can see from the article I put in this slide, it's an article in 2014. It can show that how the internet community feels about the domain name abuse. the title of this article is a good indication. And but however, the domain name abuse is not only a problem about how we feel, but also an important problem that could shake the internet governance under the Icann regime. As you can see in this slide, I put a book from published by in China. It's a challenge to the Icann's internet governance approach. In this book, it raised several advocates. It states that cyber sovereignty, they think that the cyber sovereignty should be an extension of the state sovereignty, and they think we should use the multilateralism to replace the Icann multi-stakeholder. And they also think that the government should take lead in the internet governance. Here you can see the content in page 18. It also mentioned about the domain name abuse. Here they mentioned about the phishing and the spam and also malware and the botnets. And they think that because that the governance under the Icann regime cannot effectively to address the problem incurred by the domain name abuse. So maybe we should change another governance mode. So this would be a very important issue if we cannot address the domain name abuse well. So I think the best way to address the domain name abuse is a collaboration between the public authority and the private sectors. And here in the left side, we can see how the public authority can address the problem of domain name abuse. First, the court can use a warrant of domain name seizure and the forfeiture, or in a civil procedural way, we can give the preliminary and the permanent injunction to block the domain name, or in the continental law system, like in Taiwan, the administrative agency has the authority to make an administrative decision to block the domain, to block the domain name. And in the right side, you can see here are some approaches the private sector can use to regulate the domain name abuse. The first one is like through the third-party mechanism. Karen already introduced the UDRP for us in very details. Here I also put the many. We developed this mechanism in Taiwan by the TWNIC to address the online piracy. And we also can get help by the contracted party, like the registrar or registry, and also can get the help from the non-contracted party, like free DNS hosting provider. Here the contracted means have the contract with the Icann. So in this slide, I illustrate all the competing interests in countering domain name abuse. In the right side, that would make us to think again if we block the domain name or not. Like online freedom of speech and the free flow of information and internet access of right. I remember that the Supreme Court of India have made the decision that the right to access internet is the fundamental right of human rights. And in the left side, are all the factors that support us to block the domain, like a protection of legal rights and implementation of public policy and internet reliability and accountability. So if the case comes to the court, the judge will consider all the factors here and to decide to block the domain name would be an appropriate way to counter the domain name abuse. Then we will make that decision. And here is my it's an article I wrote in 2019. At that time, the American Chamber, they announced the IP index, and they said that Taiwan cannot deal with the online piracy very well. So I wrote this article to call for the more mechanism to be implemented to tackle the domain name abuse. And very luckily, in the next year, the police found the bad guy who abused the domain, and they also seized the domain. Okay. Now recently, the police also found several cases, and they have the warrant from the court to block the domain. And the block was implemented by the TWNIC. So I think these are all very good cases. That's how the authority cooperate with private sector to enforce the court's judgment. So in this slide, you can see how the process in the court to fighting the online piracy. And the first, the police can request a court order to seize the domain name if this domain name is used for online piracy. And a second, the prosecutor can bring the case to the trial. Even the prosecutor don't know who is the registrant, or they can file in that case, the court can exercise its in rem jurisdiction. So even the prosecutor cannot know who is the owner of the website or who is the registrant of that domain name, especially because of the GDPR. So it is not so easy to know the registrant of the domain name. But even so, the prosecutor still can file a case and bring the case to the court. And the court can hold a hearing. Then we can make a decision to forfeit the domain name. And here's come the question: when the court makes the decision to forfeit the domain name, and in Taiwan, like TWNIC or other registries that based in Taiwan, like .tw or .taipei, they can help us to enforce the decision. But across the border, can the registrar or registry based outside Taiwan can also help if we report the abuse, the domain name, and provide a court order? So here is my
Henry,
hope.
Just a quick note on time as well.
Yeah, okay. The more effective collaboration would be the registrar and the registry can voluntarily help enforce foreign court orders. And the traditional mutual legal assistance, because they need to take a very long process and take a long time. So it would have very little value here. And you don't have to worry about to help to enforce the judgments, because it is because the registrar and the registry can do this in a case-by-case basis. And here's the criteria that can help the registrar or registry to help enforce the foreign court orders. First, you can consider, is it a reasonable court order or it is a political decision? Then the second is clear and convincing evidence of bad faith abuse. Actually, you can have a browse of that domain and to see the content. And the third, it involves the universal acknowledged legal rights violated, like the copyright or child pornography. And I also see from the report of another panelist, like human traffic. Okay, and here are several agreements from the registrar, also supported to voluntarily help to enforce the court's decision. Like in GoDaddy's registration agreements, or Gandhi registration agreement. And you can also see the Icann's registrar agreement, accreditation agreements, also support that the registry and the registrar can take the reasonable and the prompt steps to investigate and respond appropriately to any reports of the abuse. So if you get the court's decision, I believe that would be a very good response and a very appropriate step to counter the dominant abuse. So here I can say it again, the voluntary assistance from the registrar and the registry to enforce foreign court order is the most appropriate way to respond the report of abuse. So thank you very much to spend the time to listen to my report. Thank you.
Thank you, Henry, and thank you for a very interesting dive into the issue from a court's perspective. So last but not least, we'll have Jamie Headland from Icann to give Icann's team's perspective. Jamie?
So thank you to the host for having me. My only regret is that I can't be there in person. I would much rather be in Taiwan, particularly at this time of the day here in the United States. And I hope I'm only at least half as good at presenting this as I am at sleeping at this time of day. But I'm honored to be part of this panel, and thank the other panelists for their presentations. In the interest of time, I'm going to try to go through some of this quickly and hope to answer any questions people may have at the end. I'll go over the role of compliance, some of the contractual provisions that we enforce that are relevant to DNS security threats or DNS abuse, some of the recent audits we've done on DNS security threats, and then finally some metrics on the complaints that we handle on an annual basis. So first, Icann Compliance enforces the policies that are developed by the Icann multi-stakeholder community that become incorporated into the agreements that Icann has with registry operators and registrars. And it's important to point out that our authority is limited to the provisions that are in those agreements. So during the discussions that have been quite prominent recently on DNS abuse, there have been lots of ideas about how to address it. And some of those are great ideas, but some of them will not be enforceable by Icann unless and until they become part of the contracts, either through amendments to the contracts or through the development of new policies. We enforce these provisions, which I'll talk about in a second, by addressing complaints submitted by third parties, through proactive monitoring, and through conducting audits. Here are a couple of the provisions that are most relevant. For the registries, it's in the public interest commitments section, specification 11 of the registry agreement. And particularly relevant to this discussion is specification 11.3b, which I think somebody else mentioned, which requires registry operators to do a technical scan of their zones for potential DNS security threats, phishing, malware, and botnets in particular. Maintain reports about those and what actions that they took on them. And in the registrar accreditation agreement, someone also mentioned earlier, section 3.18, which among other things requires registrars to maintain contact points for abuse reports, either received from the general public or from law enforcement. And then most notably to reasonably and promptly investigate and respond to any abuse reports that they receive. So that's not just DNS security threats; it's any kind of abuse. They have to investigate and respond appropriately. So audits. Up until recently, our approach to audits has been to audit the contracted parties, the registrars, the registries, against the entirety of the relevant agreement. More recently, particularly in light of the discussion about DNS abuse, we've decided to take a more risk-based approach and audit those provisions that have the potentially biggest impact on maintaining the security and stability of the DNS. Back in November of 2018, we began the first of those with our audit of registry operators for primarily looking at how they comply with specification 11.3b, that's the technical scan and reporting requirement. And then this year, and still ongoing, we began our conducting an audit of registrars for primarily for their compliance with section 3.18. I'm not going to go through all of this on the registry audit, but I believe that you'll have the deck there. There is a full report available at the link here. It's the public report, which provides the observations that and the sort of summary of the overall audit. It does not contain confidential information about any particular registry. But some of the findings are that we found that most registry operators go above and beyond the requirements of specification 11.3b to tackle DNS abuse. And they do so in various ways. Less than 5% of the operators were found to have any deficiencies. All of them remediated those prior to the close of the audit. Not surprisingly to this group, some new GTLDs did not have or had little or no abuse, particularly .brands. And then finally, because specification 11.3b was inserted into the base agreement for new GTLDs, it does not exist in the majority of legacy GTLDs. So we weren't able to make any findings about how those registry operators address DNS abuse. Moving on to the registrar audit, again, we're focusing on 3.18. What we did was this was a little bit harder to design because unlike with the registries, or you can tell by the name, the domain name, who the registry is, it's not always easy to tell who the registrar is. And so we had to access bulk registration data that we received from the registries in order to compile a report using block lists, RBLs, to identify identify domain names and associate those with registrars potentially associated with phishing, malware, and botnets. We did not include spam. As many of you know, spam can be malicious when it's used as a vector to deliver these other security threats. in which case they would be captured anyway. But for many, spam is also a matter of marketing and free speech, and has forever been a controversial topic within Icann. So from the reputation blacklist, we were able to compile for a particular period the aggregate number of potentially abusive domain names for all the registrars. From that list, we decided that we would only audit 127 of the approximately 2,400 registrars that are accredited. And those were the ones that had at least 5 potentially abusive domain names or DNS security threats that were listed. Some of them were also, we also used the security threat reports that we compiled during the registry audit as well. As I said, the audit is ongoing. We hope to complete the individual audit reports soon, and then publish a general consolidated report in the next couple of months. Finally, just to go over, give you a sense of the activity and compliance related to abuse complaints. This is all abuse complaints. We received from the period of February of last year to March of this year, approximately 3,200 complaints. About 2,600 of those were closed without further action, mainly because they were out of scope. And what does that mean? That means that they either didn't provide evidence, that the complainant didn't provide evidence that they had first tried to reach out to the registry or registrar to try to resolve the issue, or it involved a CCTLD over which we have no contractual authority, or the complaint asked Icann to take actions for which we don't have authority, such as take down content. But of the almost 600 complaints that we did address or could have addressed that it dealt with abuse, about 75% of those were actually suspended by the registrar. So there's been a lot of discussion about DNS abuse and disputes over how prevalent it is or it isn't. This is just sort of one fact that we point out. Now there may be, and I'm sure there is, far more abuse than out there than we get complaints. But generally, unless we get a complaint, we're going to have a hard time doing anything about it. So during this period, we've, for most registrars, we found that they were doing what they were supposed to be doing under the agreement, and there were no formal breach notices. A breach notice, in our process, we initially work informally with the registry or registrar to try to get resolution quickly. If that doesn't happen, after basically 3 attempts, then it goes to a public formal breach. And if that's not cured within a certain period of time, then the accreditation agreement or the RA registry agreement can be terminated. So, so recently in some of these discussions, both at Icann meetings and sessions like this and other meetings with stakeholders, we've said a few things. Number one, if reminding people that we can only enforce those provisions that are actually in the agreements, and that if people want different policies or different rules to apply, then we encourage them to participate in the policy development process. Or if the registrar, think about contractual amendments. We're in compliance, completely neutral on all of those. Our point is two things. One is we can't enforce what's not in the agreements. And when people do put stuff in the agreements, we hope that it's clear and unambiguous, because it's very hard to enforce anything that's susceptible to multiple interpretations, as some of the existing provisions are. And then finally, we give advice to potential complainants to, if you have an issue, first please work with your the registry or registrar that may be involved, and only after that doesn't work, submit a complaint to compliance. And then and we also point them to the different frameworks and guidelines published by the stakeholder groups. And not because we enforce those, we don't, but we do think they have helpful information for submitting complaints. So with that, I'll turn it back to you, Edmund.
Thank you, Jamie. And I'm unable to see the venue, so I don't know whether if someone is coming up to the mic. But please, if you have any questions, please do come up to the mic, and I'm sure the technicians will figure it out how to get you to speak. So I'm opening the floor.
Yeah,
hopefully, someone has a question. But as we wait for that, I guess one of the things that in concluding actually is quite interesting. There is a question. So I'll go to the floor first, I guess.
Okay, this is Go Wei. He's a retail. And I try to go a different, not talking about the DNS abuse. I'm interested to asking, the Eamon and Jamie. When is the next turn of the new GTLD program is going? Can we expect that? Eamon or Jamie, do you know anything about that?
That's certainly a question, not necessarily directly within this particular session, but there is some relationship with this session. I guess one of the things that is being discussed in the Icann community is how we deal with domain name disputes and how we deal with DNS dispute, and whether or not that needs to be part of the critical path towards a new round of new GTLDs. But I guess a short answer to your question is, I guess it's anybody's guess. Maybe you should start a pool and try to get bets on when that is.
You mean I wonder 2021?
I doubt it will be 2021. But
Jamie,
I don't know if Jamie or others want to chime in.
Right?
So no, unfortunately, that's way above my pay grade and outside of our bailiwick. But when it is done and they come up with new agreements, I promise the contractual compliance will enforce them. My understanding is that the GNSO Council recently submitted approved recommendations that were submitted to the board. They went out for public comment. There's going to be likely be an operational design phase that will get launched to look at how it would work and what costs and what structures would need to be in place both for the application phase and then afterwards. So, but on the issue of DNS abuse, one thing that was sort of interesting that came out of it was there was discussion within the working group about whether there should be policies that apply for this round. And my understanding is the working group said that really should not apply just to this round. If there is a new policy, it should apply to all GTLDs and should be addressed comprehensively and not simply within this round.
Okay, thanks.
We have a question from online. I'm not sure how we can organize that, if the technicians can allow that person to speak. I couldn't hear it.
My audio on? My audio is on.
Yeah, we can hear you now.
You can hear me, great. Okay. Firstly, let me appreciate what Icann and the TWNIC community are doing, especially for the Asian region. The Asian region is tremendously underrepresented in Icann. Icann, as we all know, is overtly US dominated. I think that was the first point which Mr. Cooper of Gandhi.net made. The entire system is weighted against the ordinary domain name registrant. We are caught in a web of Icann's contractual agreements, which are completely unfair and biased against small domain name registrants using our domains for legitimate non-commercial purposes. When I, as a domain name holder, am using it for legitimate non-commercial purposes, where is the role of a trademark holder who goes to one of the seven UDRP providers? The providers are competing among themselves to deliver very high rates of domain transfers to these professional trademark reverse domain name hijackers. For example, HKIC is proud that they have 96% transfer of domains. Unfortunately, we find as users that our rights have been systematically stripped away by Icann. For example, I am in India. It's in Asia. In theory, I have two Icann approved registrars in India, Big Rock and Vponics. Both of them have admitted to me that they are actually proxies of fronts or resellers of a US domain registrar. And even if I register with them, ultimately the registrar of record will be in the USA. Till 2013, as a domain name holder, I had the right to say that I would not submit to the jurisdiction of the US registrar. In 2013, that was stripped away from me. Today, if I am being targeted, reverse domain name hijacked by US-based MNCs, they invariably choose the jurisdiction of the US registrar whom I am forced to register with. A domain which I have to purchase for $28 in India is available at $1 in USA. This is completely unfair. I urge Icann to insist that our national jurisdiction of India cannot be taken away simply because the complainants don't like it. I faced two domain hijacking cases. One was in Vito, where admittedly I lost. Within 4 days, I filed in India, a case in India, because that is my domicile. Under the mutual jurisdiction part B, I am entitled to file there. The registrar, unfortunately, is an idiot. Immediately,
Roy, I think it's a very important thing that you bring up, but can you wrap it up because we're running out of time?
I'll wrap it up in 30 seconds. The registrar, without waiting 10 business days, initiated procedures to start the domain transfer. My court proceeding was completely useless because the domain had already been transferred away. In an Indian IDRP against a very well-known university, I also run a university, I lost, I went to court, and not only did I get my domain back, I also got the domain of the other party, which I continue to hold today. So I'm urging Icann to make sure that our national jurisdictions are not taken away under the mutual jurisdiction clause of your UDRP rules. And I think it's 4B13. The complainant should not have a say as to where I bring my challenge to the WIPO or the provider's decision. The providers are completely biased in favor of the complainants who are paying them. Thank you.
Thank you, Roy. We are running out of time already, but I guess this is you've touched on many aspects of the Icann process, but I'm sure the UDRP is one main part of it. So I wonder if Kiran wants to respond briefly.
Yeah, very important points that the individual has made. I suppose when we talk about the effectiveness of the process, for the most part, that is a good thing in general, given that in order for UDRP to be successful, depending on how you define that success and who you are, I think it's important that it is seen to be effective as a means to resolve domain name abuse. I think, as you mentioned, I think the courts are always there, other than for .hk matters, for respondents to take their issues to. So that is an alternative. But yeah, the notion of reverse domain name hijacking is clearly something that can be a problem to individuals, as we've just heard. But I can only really say that.
Thank you, Kiran. I don't know if Henry wants to respond as well, or.
Actually, UDRP is just an alternative procedure for the court procedure, that you can file an independent procedure in the court. And and I cannot answer the question to the court question happen in other jurisdictions.
Thank you. Unfortunately, we have completely run out of time, but I thank you for the interaction. And Roy, I hear you, and I think a lot of people hear you from the issue of the jurisdiction and the issue of in a way favoring large corporations, trademark owners, and so on. So I do invite you to come participate, as Pam has mentioned in the chat. Come participate at Icann. We are about to go through a review of the UDRP, and your participation and your experience in it will help make a difference for people in the future. So with that, I wonder if I can go quickly around for just maybe 20 seconds, a last word on the topic, because I hear that there are many issues, but it seems like from the panel that things are somewhat under control. We don't have to throw the entire thing out and revamp. There are things that we can tweak, but Icann's process is where we need to work on and work with. So 20 seconds each, I guess, going through from the beginning. Thomas?
Okay, so yeah, you can hear me, right? So my point is maybe my last 20 seconds, or 20 seconds, very short. Yeah, I think for the UDRP procedure, just to add a little bit to that, I think that the panelist is supposed to be the one who's the independent force in the UDRP, right? So inside the arbitration. So we have to be maybe make sure that the panelists take more care about where the jurisdiction is of the one who's being who's receiving the complaint. And then my final word just is maybe that we have to really act about DNS abuse. We have to make more standardizations, better procedures for registrants or for people who have been affected, that they can have more standardized procedures, more international as well, not just in English. Only less than 400 million people on this planet have English as their first language. And peer, for example, .org doesn't even support French accents on their domain names in IDNs. So really, we have to be much more international. Otherwise, the governments like the EU, they will just make their own laws, their own procedures, and they will force everybody to follow that way. Thank you.
Thank you, Thomas. Crystal?
I do think that with DNS abuse, the harmonization across TLDs is definitely very important. Also, many of the partnerships that have been set up. So, where from the registry agreement, with Icann, that we do have those technical abuse policies, but with CCTLDs and GTLDs in the world, really looking at our acceptable use policies, which are across TLDs, but then really being able to utilize some of those partnerships, like a trusted notifier partnership or with IWF to be able to dig into those types of abuse, and to really be able to have a robust program from that perspective.
Thank you. Kieran? Oh, yes, Kieran.
Yeah, just very quickly, Thomas is absolutely right. I mean, the decision maker is the panelist. And as I mentioned, that's really important process for the provider to do well. Nationality is something you take into account when you do appoint. It's not a requirement, but a neutral nationality is important. But just to summarize, I think for us, it's, well, cost effective and time effective. I think that's being met to some degree. And generally speaking, having a robust panelist in place to make that decision is important. And then amongst the providers, certainly in AD and DRC, we have a committee that looks at practices and standards and considers decisions. And so if concerns arise with respect to panelists or certain practices, then those are discussed and hopefully to be addressed. But yeah, it's constant monitoring.
Thank you, Kieran. Henry in Taipei.
Yes. I just want to encourage all the registry and the registrar to enforce the warrant or the judgment of the from the Taiwan court. And by the way, if you think the UDRP decision is wrong, and please come to the court to seek a remedy. Thank you.
Thank you, Henry. Jamie.
Thanks. Just quickly, so as most people in this group know, there are lots of important discussions going on within the Icann community about DNS abuse, and a lot of vigorous discussion and debate. And I think that what's important is that that facts continue to be contributed to the discussion, so that if there are policy changes that need to be made, that those are based on facts and not on misperceptions. But I think it's also important for folks to know, as I know this group already does, that that there are perceptions in governments around the world that DNS abuse is a problem. And if the multi-stakeholder model doesn't, the Icann multi-stakeholder model doesn't come up with solutions, governments will, and we're already seeing the consequence of that kind of action, albeit unintentional, with the impact of the GDPR.
Thank you, Jamie, and thank you for everyone. And a note from the chat from Don Austin. Yes, I think the Icann community does realize that there is a lot of participation from the U.S. and it feels and views as U.S. centric, but the door is open. So you have to come. That's why we are here in this forum. We need the participation and the voices to come from Asia Pacific. Sorry again for running well over time, but hopefully it's an exciting session for you. And please join me in a round of applause, virtual, but there you can do it physically for the panel. Thank you.
Thank you very much, Mr. Zhang, for moderating the session, and thank you to all panelists for a very lively panel discussion.